and we are going to go ahead and get started this morning. Welcome, everybody. My name is Elizabeth Aloni, and I'm with Schneps Media. Schneps Media is the largest local media company in Metro New York. We publish over 70 newspapers, magazines, websites, webinars, podcasts, and events, and do so throughout Queens, Brooklyn, the Bronx, Manhattan, Westchester, Long Island, and Philadelphia. Today, we're thrilled to bring you a very important webinar entitled Plan for Your Child with Special Needs. I'm thrilled to be able to bring you these experts who are going to share with you an important topic. 1 in 54 children have autism, and as these children are transitioning to adulthood, there are important issues that need to be planned for. And today we have 2 experts who are going to be able to discuss how to ensure you have a plan in place to support your child's transition. I'm honored to welcome these panelists today. First, Melissa Negrin-Wiener, who is a partner at Cona Elder Law. Melissa, welcome.
Thank you so much, Elizabeth. Really looking forward to this. Thanks for having us.
Our pleasure, our pleasure. Melissa, can you share a little bit with our attendees about yourself and your expertise?
Sure. I have been a partner with Cona Elder Law now for about 11 years, with the firm for over 20. And we handle all aspects of, government benefits and estate planning and Medicaid planning and this area of special needs planning and disability planning has become much needed area of practice, and we've really started a huge portion of what we do has really become this disability planning, and we've worked with Deb Thivierge at the ELIJA school quite a bit, and we really look out for the whole family. So it's not just when you're planning to be looking at the specific individual that you're planning for, but to be looking at the parents, grandparents, everybody involved, and you really have to pay attention to that big picture.
Such an important thing, and that's why we are spending our full time focused on it. Thank you so much, Melissa.
Thank you.
Now I'd like to introduce Debora. Thivierge. She is a BCaBA, CBAA. She's the Chief Executive Officer of the ELIJA School, Foundation Farm TPS. Debora, please share a bit about yourself with our attendees.
Good morning, everybody, and thank you so much for having me here. This is really a wonderful opportunity for me to share my personal journey. First and foremost, I'm the parent of a 22-year-old with autism. And he is the reason why I have engaged in the community so intensively over the past 21 years of my professional career as a parent and as a working community member in the field of autism. I started ELIJA, which stands for Empowering Long Island's Journey Through Autism, specifically because of the lack of support and guidance for families when faced with a situation of a diagnosis as severe as autism, a lifelong disability. And so I started a foundation for educating families, and that morphed into opening a school to be able to provide an appropriate education to children on the autism spectrum who had greater needs. Over years, those children grew into adults. There was then a need to transition then into a support program that would be able to give them vocational experiences, leisure experiences, and being able to help integrate them into the community. So my job is never going to be over because basically, just like Melissa had said, we support families through the lifespan. And so that's what our work has been over the years. And my personal joy is really being able to support my own child, and through those experiences, I'm able to extend that education and knowledge to my friends and families that I've supported over the years. So that's really what ELIJA is here for. And partnering with other very, very important people in our lives that support us through the planning process has been a crucial mission of mine to help engage the community in making the right choices, because there's so many choices. But our goal is to always make the right one so that we don't have mistakes that cause a lot of stress in our lives.
It certainly takes a village. It certainly takes a village.
That's right.
Thank you, Deb. That's wonderful. Deb, can you share with us a bit about the unique challenges that parents of children with special needs need to consider as their children are transitioning to adulthood?
You know, for me personally, what I have really been struggling with supporting families over the past 20-something years is the exhausting nature of being an advocate for your child. From the minute you get that diagnosis, you are nonstop as a parent and engaging all of your family members to be part of this process, doing everything you possibly can to get everything that they need to be successful in the future. But what ends up happening is our advocacy as parents exhausts us. Many of us have the difficult task of fighting to get proper services, fighting to figure out what's wrong, how to make it right, how to make things better. Just getting and gathering information can be exhausting. And by the time children get into that phase where they're planning for transition, around 14, 15 is when they're legally supposed to be transitioning, doing transition planning in the educational system through IDEA. By the time kids actually graduate, whether it's 18 or 21, families are exhausted. They are exhausted because what they realize is that having a child never really ends, right? Having a child with special needs, the advocacy and support also never ends. In fact, sometimes parents realize when their kids are getting ready to graduate high school that it's really just the beginning. And we are at power level 0, and we need a major recharge. And so our efforts have been to make sure that families are prepared for this scary dive off of the cliff, thinking that something is going to be there for you when your kids graduate and when they're ready for their next phase. And it's not. What the expectation is a bigger burden and bigger stressors for planning. Parents are older. Parents may no longer be available to do this level of advocacy. They might have their own personal health issues. And so it's super stressful. So what I've seen through my experience over the past, we've been doing our transition program for about 5 years now, is that jump from going from the school bus picking and dropping off your child to that no longer being a benefit is frightening. And so what I've seen is parents wake up at that point, realize they need, oh my goodness, I heard I need guardianship. My kid's 18, I need that. And then where is he going to be? What is he going to be doing? Where is he going to be living? I heard about benefits. I heard about that they can get services. And all of these things take a really long time to organize and plan for. So if you jump off this cliff and you're just starting to plan, you've just increased your stress and anxiety level like triple fold. And the ultimate goal is for our kids to be meaningful participants in our community, that they can have meaningful relationships and be contributing to our communities, in whether it's through volunteer or through actual paid work. And so what I've seen is so many stories, and Melissa, this will be a good transition to Melissa, where they were just so busy trying to get their kids to graduate that they had blinders to the warning signs of what was coming their way. And I have worked with families where you have two parents raising a child with severe needs, and one parent suddenly passes unexpectedly. And to watch a family go through that turmoil is, one, the loss is beyond anyone's wildest imagination. And once you're able to pass through that horrific challenge, what you're left with is a list of planning that is sometimes overwhelming to handle. And we are not a society that prepares our families enough for this process. This could be done much sooner to avoid the enormous burden that families have. Where are they going to be living? Where are children going to be when we're no longer here to support them? Are they going to be able to go to college? What's entailed in doing that? What kind of support services will my child have when the family is no longer accessible to them as guiding them through their journey? What if they don't want to or are not interested in guiding them? There's no replacement for a mother or father figure. And we've learned that it's an impossibility. But I will tell you this, the last thing that I want to say is no matter what happens to our children, we have to understand that there will never be someone to replace mom and dad or those representatives, whether it's through legal guardianship, whether a sibling acts as that role. So we have to be, when we're here and when we're able, we need to plan for those, what that will be like and what that will feel like while we're still here, so we know that we've done our job. So I want to pass it on to Melissa, who has been an incredible support system for families who are going through these times when it's an emergency, but she's also there to be a wonderful support system so that we can plan this all out. So it's such an honor for me to be presenting with her. I've learned so much, and I look forward to our conference on March 25th, which is going to be a full day of talking about all of these things that we should be aware of and red flags that we need to start thinking about. And so that you can get the information at elija.org, elija.org, and I think Melissa's going to have a slide. But thank you again for letting me share those stories. And obviously, if anyone has any questions, please feel free to ask or reach out.
Thank you, Deb. That was really important and so important about plan, how critical that is. The program that Deb was talking about, I am going to share information about that program via the chat here. And I'm also going to share it with you. You'll get an email tomorrow that'll have information. It's a full day virtual event that really goes into depth of this transition time for children with special needs. So I will get that information out to everybody. Thank you so much, Deb, for sharing all that information. Melissa, I would love for you to share with parents how they can prepare. We've talked about how important preparing is. Now let's get down to it.
Thanks so much. And thanks, Deb. I'm going to share my screen. So let's just, this.
Looks good.
Looks good? Okay, terrific. Okay. We can do those later. Okay, so the eye-opening situation for me with all of the need for planning, and we talk about the need for planning all the time with everybody and anybody, but I was invited to speak on a panel with a financial advisor and an accountant to families of children with special needs. And I was absolutely blown away by the amount of people who had no planning in place. And that's kind of where this grew out of. It's a natural fit with elder law and estate planning, but it's something that just really, really surprised me. And so it kind of became my personal mission to really get information out to people. So like I said earlier, a lot of what we focus on is this multi-generational estate planning when you're planning for a child with special needs. So talking to the family, talking to the parents or to the grandparents first and saying, do you yourselves have your estate planning documents in place? Do you have your will? Do you have a trust? What are you doing as far as asset protection planning for you when you become older, if you become ill, if you need care, whether it's at home or in a nursing home, and what's going to happen with your assets when you pass away? And really, have you put that type of planning in place to make sure that your child is not negatively affected down the road? And people don't always think about that. They're kind of, like Deb said, very focused on the child, making sure that they're getting the services that they need, making sure that they're advocating for them in the school system, making sure that they have everything in place. And I've watched it happen, and it is hundreds of balls in the air at one time. So really, who's thinking about their own planning? But your planning as a parent totally affects your child, and even more so if your child has special needs. So very important to pay attention to really everybody up the line in the child's family to see what's going on with their own estate plan. And also to consider any other relatives who may be leaving assets to your child. So, often maybe there's an aunt or an uncle who never marries and doesn't have children and says, well, I'm going to leave assets to my sister's son. He's going to need it. He has whatever the needs are, the extra money will do. I'm just going to leave it to him. But not thinking about the fact that, well, if that child is on a government benefit, leaving the assets outright to him or her is going to cause major issues for the child, and also result in the loss of probably in the loss of a good amount of those funds that you're really intending to help the child with. So it's so important to make sure that we're checking beneficiary designations on insurance policies and retirement accounts. And really just communicating with family members, because there are ways to set all of this up so that we're protecting the child down the road. And that's really by talking about special needs trusts, supplemental needs trusts, and we're going to get more into that as we move forward. But I just wanted to kind of drive home the fact that, of course, this is about the child turning 18 and getting their planning in place, but we also want to focus on your planning as well. Now, let's talk about the child a bit. Can your child sign an advance directive? So when we first meet with a family with a child who has special needs, like Deb said, the transitioning sometimes, 14, 15, most of the people I see, unfortunately, it's a phone call of my child is turning 18 next month and I didn't do any of this. Now, that is not really a far cry from what I deal with my elderly clients as well. The planning piece is so important, and unfortunately, it's not on the top of everybody's list. So there are things that we can do, obviously, and really most important is for me to meet the child. So sometimes it goes without question that the child is going to need a guardian, that they can't understand, a power of attorney, a health care proxy. They can't really understand or communicate who they want to name as their agent under those documents. And in those cases, we know that we're moving towards a 17A guardianship, and I'm also going to be speaking about that. But sometimes when I meet with a child who's 17 years old, and we have a conversation, and while they might be on the spectrum, they may have autism, they are high functioning, and they can talk to me and tell me, that they have a bank account, and, that their parents help them and how they pay their bills, and, a very comfortable conversation, and that they understand if they're signing a power of attorney, that they're giving their parents the ability to handle anything financial that comes up for them. And also, very importantly, a health care proxy in case there are medical decisions or emergencies and things that need to happen. And typically they'll tell me, yeah, my mother takes me to all my doctor's appointments, and she talks to the doctor and she comes in with me. And that's terrific. And that's what you would expect. But once someone turns 18, whether they have a diagnosis of autism or they don't have any sort of diagnosis, once you turn 18, your parents no longer have the legal authority to make any decisions for you or get any information regarding your health care. So it's always been a very, very big part of our practice to drive home the fact that when people are turning 18, they need to have a power of attorney, a health care proxy, and a living will, or at least the power of attorney and the health care proxy in place. Children who go off to college and they're in another state, God forbid something happens to them, the parents may get a phone call, and we've certainly had this happen, where the roommate calls and says, Mr. and Mrs. Smith, something happened to your daughter. She's on her way to the emergency room. She's not conscious. And now the child can't give the doctor's permission to speak to the parents. The child's over 18, and we could have some major issues on our hands, especially if we're in two different states. So that becomes a catastrophe. And it's so important to have this planning in place. Again, I'm talking about anybody who's turning 18, but, really focusing on a child with special needs. There's been many times where I've thought I'm going to be doing an Article 17A guardianship, but I meet the child, I have the conversation, and I'm totally comfortable with them signing their own documents. And it's been really you know, an interesting ride, kind of having those meetings and having those conversations and, you know, watching the dynamic between the family members. In New York State, just as a quick aside, when you're talking about a healthcare proxy, you can only have one agent at a time. So it's an interesting conversation with this child who's really been so dependent on their parents, you know, since day one, to, you know, feel like they're choosing between them. And, you know, it's a very interesting dynamic, and it really puts the training of a mediator, which I am, into play, and also just, you know, the counselor at law idea of really being a counselor and working through this with the families. So it's something really important to make sure you're comfortable with the person who's working with your family. So the power of attorney is a document that you put in place to make sure that there's someone to handle financial decisions if the individual can no longer handle it themselves, whether it's from an illness or an accident or an injury. The healthcare proxy is putting someone in place to make healthcare decisions. And the living will is a document where you state wishes regarding end of life decisions and whether or not you want heroic measures taken to keep you alive. If you have a condition that's likely to cause death in a short period of time. And not to be completely repetitive, but just to drive home that these documents are really important for everybody. Now, moving on to, well, what happens if the child cannot sign a power of attorney or a healthcare proxy? So again, like I said, it's either going to be right off the bat where the parents tell me, you know, that their child cannot understand, that they are not high functioning at all, and this is what we have to do. This is the road we're going down. Or after a meeting with the child, I've determined that I'm not comfortable with the child signing the documents, and that I don't feel that they can completely understand what it is that they're signing. Then we're going to go the route of a 17A guardianship. And the 17A, just so you know, is the statute that governs this type of guardianship. So that's where that terminology comes from. And it's something that we're going to do just before the child turns 18. Now, there are two types of guardianships. There's also something called an Article 81 guardianship, which again is the statute 81. And the Article 81 guardianship is more driven towards, you know, older people who maybe have a dementia diagnosis or, you know, don't have the power of attorney, don't have the healthcare proxy, and something happens to them and they can no longer sign those documents. And now we're in court having somebody appointed as their guardian. The 17A is very different. And it's really for this universe of, you know, a child with a developmental disability with special needs. And it's almost purely diagnosis driven. So this is the diagnosis. This means the person really does need a guardian. And the powers are different. So in an Article 81 guardianship, we can tailor the powers, we can kind of play with them to make them, you know, for the person who's actually in need. What's going on in their life? Do they need to sell a house? Do they need to go to a nursing home? All of these kinds of things, and we can tailor those powers. In a 17A guardianship, you're basically saying, most of the time it's mom and dad. Mom and dad have had these powers as the parents from day one, and we want those powers to continue. So basically, the everything and anything that a parent has done for a child will continue after the age of 18. And the whole thing, the 17A, was originally enacted so that the parents of the child could just continue acting as the parents of the child. And this is always a fun conversation because, and I'm a parent myself, my kids are younger, but it's a fun conversation because the parents look at me and they're like, 18, like I'm still paying for everything. I'm still, you know, they're still living in my house. What do you mean they're not a kid anymore? Well, legally, we need to have this guardianship in place so that you can continue making all of those decisions for that child. Another big difference is the Article 81 guardianship is brought in Supreme Court, where the 17A is brought in surrogates court. So, you know, different locations for the two different actions. And with the 17A, really no hearing is required when the petition is made by both parents or surviving parent if one of them has passed away. So if everybody's on the same page, typically this is all going to be done through documentation. Occasionally, a guardian ad litem may be appointed for the disabled child. That does not happen all the time, but the court has the right to appoint somebody off a list, it's typically an attorney, who's going to kind of be a guardian for that time period during the hearing to make sure that everything is being done in the best interest of the child. And I've seen this done in cases where maybe there's a large settlement, there's a lot of money, and there's some questions as to how the parents have been spending the money. Is everything being done for the child? And in cases like that, sometimes the court will appoint a guardian ad litem to kind of report back to the court and say yes or no, everything is going along appropriately. With an Article 81 guardianship, we always have a hearing. Most likely the alleged incapacitated person in that Article 81 is how we refer to the individual who's the subject of the guardianship, will have to be there, even if they can't necessarily communicate, depending on what the court decides. And again, it's a full-blown hearing, where in 17A, it's submission of medical certifications by treating physicians and filling out a petition, and basically the decisions being made again by the diagnosis, the doctor's medical forms, and being basically done on the paper. So it's a very, very different process. So an attorney who deals in guardianship and just does Article 81 is going to kind of go for a wild ride the first time they do a 17A. So it's really important to make sure that you're dealing with people who, know that process. Okay, so just to move on to, okay, so what happens next? Well, there's different ways to protect assets. So once we have the child, protected, we know the child either has a power of attorney and a healthcare proxy, or there's a 17A guardian in place. And I just want to add one thing, because this just came up with a case that we have now. It's also really important to name a standby guardian. So you name a 17A guardian, again, typically it's the parents. And we always say to the parents, hey, who's going to back you up if you can no longer do this? Like Deb said, the parents get older, maybe they need their own care and they can no longer act as the guardian. Instead of going through the process of a new petition, let's put somebody in place now, whether it's another sibling or some other family member, if we know who that is, and it can be changed as we move forward. But I just had a case where I have an adult, a disabled child, parent now needs Medicaid himself, which we're doing, but the child, he's the guardian for the child through the 17A guardianship that's years and years old. And now we need to change the guardian. And thankfully we have a sibling who is named as a standby. So it's really just a quick matter of some quick court papers, and we can then change that guardian over to the standby guardian. So that's also something really important to keep in mind and talk about. But once that's all in place and we know, okay, the child is going to be, have somebody making decisions for them, is going to be safe in that regard, we want to talk about the finances and how we're going to protect this child. And really the way we do that is with special needs trusts, sometimes referred to as supplemental needs trusts. And there's different types of trusts. So I just want you to keep in mind, because the statute refers to the trust as supplemental needs, but in practice, they're referred to as special needs. They're essentially the same thing. There's a first party, a third party, and a pool trust. So I'm going to kind of touch on those three and how they work. Now, there's also a trust that could be created during lifetime, and trusts that can be created in your will for your child, or in the grandparents' will for that child, or in anybody's will for that child. So that we refer to as a testamentary supplemental needs trust, because that trust doesn't come into being until the parent, grandparent, whoever it is, passes away. Okay, so let's just talk about the first party trust. The first party trust is when the trust is set up with the child's money. So that would be a case where maybe there was some sort of settlement and the child came into funds, and those funds are going to go into a trust. Or that could be where somebody left assets to a disabled person outright without setting up one of these trusts. So now the money's coming to that person outright and they need to do something with it. Now, why are we so worried about there being money in the child's name? Well, if you're collecting benefits like SSI, supplemental security income, you can't have more than $2,000 in your name. So we don't want to have a situation where we have a child who's receiving benefits who has, this chunk of money that's now sitting in their name, and they're going to lose their benefits. And if they transfer the money to somebody else, they're going to have a transfer penalty. But if they put it into a supplemental needs trust, there's no penalty. The money does not count as theirs for purposes of government benefits. The money is actually meant to supplement, not take the place of government benefits. So we have this trust sitting with money in it. We have a trustee appointed. That trustee can use the money for the child, for whatever the child needs. Okay, the money's never going to go to the child. And the child can still have their small bank account and then still get their government benefits. So it's a type of trust that really works to protect assets for somebody who's receiving government benefits and can only have a certain amount of money. So the first party, like I said, is set up with the money that belongs to the child, whether it's, again, money that they received from some sort of settlement or money they received from another person who left money outright to them. The third party supplemental needs trust, I would say, is a lot more common. And let me just back up 1 second. I'm sorry. For the first party supplemental needs trust, that can be set up by a parent, a grandparent, a guardian, can also be set up by the person themselves now. That was not something that was the case when I first started practicing. And so now a person who has capacity, who's higher functioning, who's able to understand and execute documents can actually create their own supplemental needs trust, which has made a huge difference in doing all of this. But the third party is set up with someone else's money. That's the simplest way to kind of look at it. So this is if a parent has a child with a disability and the parent says, I want to set up a trust now while I'm alive, put some money in it for my child so that there's this pool of money that the child, and name a trustee, which could be the parent, and that's the person who's going to utilize those funds, but the funds are for that child. More common is the testamentary supplemental needs trust, because mom and dad are taking care of the child while mom and dad are alive. So mom and dad say, well, in my will, when I leave my assets to my children, however I do that, I'm going to leave Joe's assets, if Joe's a disabled child, in a supplemental needs trust. So when mom and dad pass away, whatever Joe is supposed to receive will go directly into a supplemental needs trust that is created at that time. That's a third-party trust. Now, the major difference on these two trusts is this. If it's a first-party trust set up with the disabled person's money, it is a payback trust. That means Medicaid, let's say you're on Medicaid, because after you have SSI, when you have SSI, you're automatically getting Medicaid benefits. Whatever Medicaid has paid out gets paid back when the disabled individual passes away from the first party trust. And then if there's anything left, there'll be a beneficiary that's notated in the trust document. A third party supplemental needs trust is not a payback trust. So when it's set up with someone else's money, or it comes directly from an estate to a supplemental needs trust, it is not a payback trust. And in my example, mom and dad can actually say, this is a third party supplemental needs trust for Joe. And if there's any money left over when Joe passes away, it can go to my other 3 children or whoever they choose. So that's the major difference between these two trusts. Whose money is it set up with? And then what happens when the disabled individual passes away? The pool trust is similar in that you can have a pooled asset trust, which is somewhat similar to this type of supplemental needs trust. You can also have a pooled income trust, which is for working individuals who say have excess income, or people who are elderly and are getting a fixed income that's over the allowable limits to protect the excess income, or again, very much like the third or first party, to protect excess assets. The difference with the pool trust is it's run through a non-for-profit, and those non-for-profits, they're the trustees. So very often we would set this up in a situation where there's no family member to act as a trustee, or if the person setting it up would rather have this kind of not-for-profit or corporate type trustee as opposed to a family member. So that's the major difference there with the pooled trust. So these are the types of things that we discuss when we sit down with families. If there's a child with a disability, do we want to set it up now? Do we want to set it up in your will so that it doesn't come into being until later? But this is where we sit and have this conversation of what assets are out there, what assets have named beneficiaries. You could have a brokerage account naming your 3 children as the beneficiaries, and unfortunately, you could have your disabled child as one of those beneficiaries, and it's going outright to them. So now they get it outright when you pass, and their only option is this first party supplemental needs trust. Whereas you can actually make the beneficiary your 2 children, and then for your 3rd child, who's a disabled child, their trust. So we sit and talk about all of those accounts, life insurance, anything that you have or that your family members have that they might be leaving to this child, to make sure that everything is going to the right place. And one of the absolute worst things that can be done, and I know people do this out of the goodness of their hearts, but for planning purposes, I hear all the time, I'm just going to leave everything to my daughter and she'll take care of my son. And it's a very common thing to do. I highly recommend putting the assets that you want for your son, in that case, into a supplemental needs trust. Let your daughter be the trustee, but let's earmark that money for him from tax perspectives, from gifting perspectives, from the daughter giving him money. What if the daughter has to move across country? There's a million what ifs. So that's something that, really have to take into consideration. But we do see that a lot, and it's not something that I personally do not think that it is an ideal setup. Deb, you want to chime in here on that type of thing? Because I know that you probably hear a lot about that and kind of what can go wrong there.
Yeah, I mean, there's so much that can go wrong. It's a little frightening. And I think the hardest part is once you realize you're there, any kind of repair is so lengthy. It can be years. I've had so many families come to me who weren't even aware that these were issues that they needed to pay very close attention to. I think that starting out really early on, understanding the future of what is going to happen financially is one of the most crucial factors, because even right now, ELIJA's working on housing with some really, really skilled and talented individuals who are expert in this area. And this one part that you're talking about specifically right now is what really holds up the families to be able to have a benefit that prevents them from exhausting all of the assets that have been protected for so long. So I guess in essence, you really need to know, you need to plan what the future is going to look like and what you expect, because this way you have to work your way backwards into structuring your financial it's not just you have to have a lot of money for your kid. We know that. It just has to be in a way that you can maximize the benefits to protect them so that they can live an independent and fulfilling life that they choose to live. So I think that's where it's really frightening. And being in that position where you've made a mistake like this it's beyond. The stress of being in that situation is incomprehensible. You just don't want to be there. It's just like life insurance. You don't want to be in that situation where your family is not protected. It's very, very similar. Mm-hmm. And you need to work with people who understand what the trajectory is of what the structure, not just you have to have X amount in a bank account, but how is it going to get utilized? And so I totally agree with you. I think that this is an area of a knowledge base where I wish that, and Melissa and I talk about this all the time, we wish there was a course in college and in high school that taught you how to care for your loved ones, whether it's the elderly or individuals who have disabilities or other types of needs that are unique, because I wish someone would have told me. I would have been the top A student.
Absolutely. Thank you, Deb. One last thing I just want to touch on is something called the ABLE accounts. ABLE standing for Achieving a Better Life Experience. And these are bank accounts that can be owned by the individual and designated beneficiary of the account. So this is an account that, a person with a disability, they can have this account in their name. It has to be established by an eligible individual, and that individual has to be blind or disabled by a condition that began before their 26th birthday. So this comes into play a lot when we're talking about children with developmental disabilities and as they get older. And people are limited to one ABLE account. But the assets in the ABLE account do not count towards the resource limits for government benefits. So just like the Supplemental Needs Trust, the money that's in there is meant to supplement your government benefits and does not count as a resource towards your ability to get those benefits. So it's modeled after the 529. It's similar to the college savings plans. And an individual is permitted to deposit up to $15,000 a year into the account, which will grow tax-free. And the money in the ABLE account can be used for things to improve quality of life. It can be funded by family members or friends. And again, the assets in the ABLE account, they're not counted as a resource for Medicaid or SSI, but they're also going to be a payback. So similar to that first party supplemental needs trust. I like this in that I feel like it gives people a little bit more flexibility to handle their assets and to learn how to handle money, and because they have a little bit more access to it. So it's something that we talk about. It may come into play in some cases, not in all, but something I wanted to make sure that I mentioned this morning so everybody knew about it. Just the last slide here talking about the virtual conference that Deb mentioned earlier that's taking place on Thursday, March 25th, and it's a full day conference talking about all of these types of things, plus everything that Deb was mentioning about transition and housing and education and all of the things that come along with this. And it's a really unbelievable universe, and the information is really just beyond. I mean, I've attended and spoken at many of Deb's conferences, and the amount of information that families get from that day, it just can't say enough about it.
Thank you.
Fantastic. That's wonderful. And we're going to share, as I mentioned, I did put it in the chat, but you'll get an email right to the email that you registered for this webinar. You will get this information emailed to you, as well as information I put in the chat too about how to contact Melissa. It's up here on the screen right now, but I also shared it with you in the chat. And again, we'll share it with you in an email. And Melissa has so kindly offered a complimentary consultation when you reach out. So please do. I do have a bunch of questions that I would love to be able to address before we have to say goodbye. And again, if we don't get to all of your questions, please reach out to Melissa. Certainly many of your questions may be specific to your needs. And she can address them. But if it's okay, Melissa, I'd love to get started in some of these wonderful questions from our attendees.
Sure.
Terrific. So Joseph asked, how do the guidance counselors, and Deb, this might be for you as well, how do the guidance counselors help their students transition from high school to college? Joseph is concerned in his area, the guidance counselors don't seem to be doing much in that transition planning.
They're required by law to actually create a level 1, level 2 transition plan. And these are assessments to kind of figure out what their skill sets are. They're supposed to interview the students in their schools to figure out what are their hopes and dreams, what kind of employment, what are their expectations. There are several school districts who do an incredible job of transitioning their students. There are way more that do almost nothing. And it's really frightening on many levels. Parents sometimes aren't even aware, even if they have young children in school district programs, that they have access to Medicaid services just because their children have a disability. And there's just not a lot of transparency or knowledge base within districts for this information to get to them. So I think what's important is just like advocacy for services, to link with these groups online in your neighborhoods or in your districts that understand what's available. There's always a parent who knows everything and how to access everything. And you need to be able to know what you're supposed to be at. You don't know what you don't know, and that's what's so frightening. So you need to get to a person who does know everything about anything and everything. And then this way, you can be more knowledgeable asking the questions. What will happen is we say, hey, aren't you supposed to transition me? They'll be like, yeah, we talked about that. We're helping you apply to college. Oh, okay. No, it's supposed to be based on their unique needs and what is required, and explaining to them what's accessible, what programs are available. There are a lot of individuals with developmental disabilities that can go into vocational programs when they're 18. They don't have to stay in their public school until they're 21 if they want to continue the services. There are programs that they can access that they don't have to be stuck in their high school programs. They can go into other programs and get vocational experience if they're not ready to go to college or don't want to go to college. So that's really, my advice is try and gather information, use Google, use Facebook, use social media to access what you can get. And obviously when you're working with professionals in the field, they will also be able to give you some guidance.
This level 1, level 2, when should parents expect or ask for that in high school? Because you were mentioning about the 14, 15-year-olds. So what grade should parents start to ask about this and advocate for it?
Well, transition is always something that parents should be thinking about. I believe, and we are going to have a special education attorney at our conference talking about the actual legalities of transition and what you're supposed to be expecting from your school district. I'm pretty sure it is still 14 years old is when you're supposed to have that first conversation. It's usually a 5-minute check-in because 14 is barely, no one's ready to talk about it, right? Everyone's happy to not talk about it at 14. And then every year after, if individuals have IEPs, there is a section on the IEP that says transition planning, and it goes into the specificity. Parents should ask for as much detail as they need in those plans, and they can be requesting for services related to transition, things such as travel training, things that are going to lead to independence once they graduate. So there's a lot to be discussed in transition that is left unsaid without a parent having a better idea as to what they need to be asking for. But it is part of the transition planning required through IDEA.
That's important to know, very empowering to know that information. Thank you, Deb. We have a bunch of questions about the 17A guardianship. Denise wanted to know, can guardianship be done before the age of 18? And William wanted to know, can a 17A guardianship be brought to surrogate's court for a child who's already turned 18?
Yes and yes.
Okay.
Ideally you want to have somebody in place when the child turns 18, but many times, we are dealing with it after the fact. It too depends on the child, in a situation where a parent is not really concerned that a child's gonna, try to, sign themselves out of a program or something like that, they tend to be a little bit less kind of on top of it, as opposed to the people who know, we have to have somebody in place at 18.
So there are options for both. Obviously, it's better to do it at 18, but once they're 18, you don't have to feel that it's too late.
Right.
Okay, great. Philip wants to know, can a brother or sister do a 17A for their sibling?
Yes. Yes, it doesn't have to be a parent. It's typically a parent, I would say, but it doesn't have to be.
Okay. And he also wanted to know, does a first and third party trust need to be separate trusts, or can the money be designated as such in one trust?
No, they have to be separate.
Okay.
So there are many times where a child or an individual with a disability may have both. They may have a first party supplemental needs trust that they've set up with their own assets, or somebody has set up for them with their own assets. And they could have a third party that maybe the parents left them money when the parents passed away. So it's absolutely possible to have both. They can't be combined.
Got it. Thank you for that. Rockio had a few questions. He wanted to know what would be a good practice for a family to stay on track before running against time, or if they have to encounter delays, and who should be a part of these conversations. I mean, obviously, as what you've shared here, as soon as possible, you should sit down with an attorney who specializes in these type of accommodations and plans. But who else should a parent have? Schools, provider, doctors? Should there be recent assessments done when these meetings happen? Can you give some direction about that?
I think Deb can speak to this too. I would say from the legal perspective, sometimes we'll involve a financial advisor, depending on the assets that we're talking about, and obviously the other family members. Perhaps if you're going to have a standby guardian named, like let's let them know what they're what they're going to have to do, what their obligations are going to be. But I think if you're talking about kind of the team of dealing with the whole transition. I think that we're also going to have people like Deb and, other advocates involved in those conversations.
Yes, and some important documents are neuropsychological evaluations, Vinelands, which determine the functionality, which will help determine what kind of services will be available, attorneys that represent their rights in education to make sure that the last couple of years that if there are issues with accessing services, that you're protecting those services. There are a lot of families who are pushed out of their school districts at 18 because their children are able to pass regents and standardized tests, but they have no ability to function in life because they're lacking just general life skills. That needs to be protected. Children have the right to stay in their school district programming and supported educationally until they're 21, provided that they've met certain standards. So there's a lot of analysis of what is the right decision to make sure that they're not thrown into this adult world without those supports. Again, financial planning, experts who are independent experts who know the child, who have worked with them, consultants, psychologists, psychiatrists, all of those individuals should be contacted well in advance to actually transitioning to make sure that they're part of the team of determining what is a realistic end result for their productivity in the world once they leave. Are they going to be candidates for college? Are they going to be candidates for paid employment? What are the barriers to being able to function? Parents have such high hopes and expectations. Finding a job today as someone who is neurotypical, whatever that means this day and age anymore, is a challenge. Having differences in communication barriers makes it that much more challenging. So to be very realistic about employment opportunities and educational opportunities. So those are some of the major things preparing for transition.
Now, a parent was asking, you're saying about how, early, and we were talking about the 14, but, I have a parent, Catherine, saying my child's 11, and Lisa and Jennifer have a 6-year-old. Are these things that they can be thinking about now and putting, Melissa, should they be meeting with you at that stage?
Yeah. Well, from my perspective, it's going to be more at that point about the parent and the parents planning. Because obviously we're not going to be in the situation where we're doing advanced directives for the child yet or anything like that. But we want to make sure that the parents and, parents of young children, whether they're developmentally disabled or not, very often they kind of don't do this, and they don't really think about, well, what happens if something happens to me and my spouse and there's nobody to care for the child, and who is the guardian going to be for that child, just being under the age of 18 if something were to happen to the parents. So it's the same thing here. It's just as if not even more important to make sure that the planning is in place for financially with the supplemental needs trusts, and also with named guardians in case something happens to the parents. And Deb and I talk about this all the time too. All of these kind of special things that that you want to make sure, if someone's taking over for you, like you said, you can never replace mom and dad. What are the likes? What are the dislikes? Sometimes children, they don't want to be hugged. They have those types of issues going on. And there's all these little things that you need to get down on paper and make sure that that people know, because if something were to happen to you and these individuals are taking over the care of your child, you want them to know everything.
Look, we hope and pray that we're here to see our children into adulthood. But as we all know and have seen with everything we've gone through just with COVID,
Right.
There's really no guarantees, and making sure that you have a plan in place if you have a child, and particularly a child with disabilities or special needs. It's critical that you make sure that your plans are clear and that you work with a professional who knows to ask the right questions. Because honestly, like, you're bringing up things that maybe I wouldn't have thought of on my own. So you really need a professional who can guide you to make sure that you're thinking about all the scenarios that, quite honestly, we don't want to think about.
Right.
But we really have to.
Mm-hmm.
There's been a couple questions here about, if parents are divorcing and one parent wants a trust, or one parent wants to set up a guardianship, and the other doesn't want to do anything. Can the interested parent go forward with establishing a trust? And also, in terms of guardianship, can one set up a guardianship, or do both parents have to be involved with that? What are the legalities around that?
Well, for planning, sure. I mean, individually, they can set things up. That's not an issue. With the Article 17A guardianship, it's more of an issue of just how involved the process becomes. So when it's both parents or the survivor of the parents, that's when you have just the petition, and it's kind of more streamlined. Whereas if there's issues over who's petitioning and who's going to be the guardian, and one doesn't think maybe that there's a need and the other does, then you just become more involved in the process, right? The process becomes more of a maybe you need more medical information, maybe you need a doctor to testify, maybe there has to be a guardian ad litem appointed, like I had mentioned, who's kind of the eyes and ears of the court, and representing the best interest of the child to make sure that this is really what should be happening. So it can be done, but I would say the process itself will be more involved.
Okay. Well, honestly, we could spend the entire morning and afternoon with you, but because these really, Melissa, Deb, I mean, the information that you're providing is so valuable. And I know I've enjoyed learning all of this with you, and I know that our attendees have as well. But I want to be respectful of everyone's time. Certainly, Melissa has been very generous in offering a complimentary consultation if you reach out to her. And again, I have put her contact information in the chat. And I will do that again right now, but also please note that you will also get an email tomorrow that will include all of her contact information. It'll include the information about that incredible event that Deb shared with you on March 25th, which is a great place to get more information and be able to connect with other people in the same situation as you, to be able to continue that relationship and that information sharing. You will receive a link to be able to watch this recording and be able to watch it again and be able to share it with others. So we will give all of that to you right in your email box. I want to give a big thank you to Melissa and Deb. Thank you so much for this information and for being so generous with your time and information with all of us today.
Thank you so much for having us.
Thank you. It was great. Thanks. It was great to see everybody, and I hope you're all doing well.
Thank you. And to all of our attendees, thank you so much for sharing some of your morning with us. I hope you found this informative and you can take away that it certainly takes a village and planning, but if you do get started on that, you can find wonderful people like Deb, like Melissa, who can help you guide you on that path. You don't have to be alone. So I hope you all stay safe, stay healthy, and we'll look forward to seeing you on a future webinar. Have a great day, everybody. Bye-bye.
Bye-bye.